My guest at this time is one of the top labor lawyers in the United States. It is Lucas Middlebrook. Lucas, thank you very much for taking the time to chat with me today.
Thanks for having me. Glad to
Wow.
be here.
Well, Lucas, you have done so much in the world of labor law. You've helped so many people unionize and take care of themselves. Before we dive in here, because I'm specifically going to talk to you a little bit about what is going on right now with the world of professional wrestling. But for you, Lucas, just so people get to know you a little bit, what attracted you to labor law? Why did you find yourself in this line of work?
What's interesting is that the firm that I'm a partner with now, I originally started working for while I was in law school. And that was one of the main focuses of that firm's practice was labor law and to some extent, well, to most extent, labor law on the union side of things. And so I interned with that firm for a few years in law school, and then I hired on full time right out of law school and have not moved since. And that was around 2005 when I graduated law school. And this is just always what I've done, but it's also something that I'm very passionate about. I had two grandfathers that were both union workers, one in the airline industry, and then one who was actually a teamster driving cement mixer trucks. And so they were always good, hardworking union men. And it's just something that I really believe in, that unions can lift up the workers and help balance the differences in balance in bargaining power that without a union can be quite troubling for employees.
Absolutely, or independent contractors, So with that, before we get to the wrestling, Lucas, I know you've worked with a lot of different entities. Give people an idea out there of some of the different entities and people you've worked with to help unionize so far in your career.
Sure. So I serve as counsel to the National Basketball Referees Association, which is the union that represents the NBA referees. And my firm's been representing them for a little over 10 years. I also represent the Professional Soccer Referees Association, or PSRA, which is the union which represents the Major League Soccer officials. And that one's actually very interesting because in 2012-13 time period, that group did not have a union. And they were treated as independent contractors. And that group took it upon itself. They had heard through the grapevine that we represented the NBA referees, reached out. And so I actually assisted with their organizing drive. And they went through a contested election at the NLRB. They collected cards. They went through an election. And they were certified as the representative in 2013. And they are actually on their second collective bargaining agreement now.
Oh.
And their terms and conditions of employment have ameliorated quite significantly since prior to being non-union. And then I also have represented some fighters in the UFC. I represented Nick Diaz back in 2015. That was not with respect to union issues, but instead I represented him in front of the Nevada State Athletic Commission, after Nick had tested positive for marijuana in his fight with Anderson Silva.
I recall.
And from that representation, I got involved in an organizing drive of fighters at the UFC called the Professional Fighters Association, or PFA. And that involved a baseball agent by the name of Scott Boras. And that percolated along for a little while. And that's actually where I met Leslie Smith, who was a former fighter in the UFC, who then started her own organizing drive in the UFC, who I believe you've spoken to.
I have, yes. Yeah.
And then I also represented Leslie when she filed a charge with the National Labor Relations Board after she was let go, for which we believe was her union activity at the UFC. And then I also represent a number of unions in the airline industry, the Southwest Airlines mechanics, the Southwest Airlines flight attendants, mechanics at Alaska Airlines and some other airlines as well.
So you've successfully helped to unionize these different pockets. I'm real interested to get, and again, the wrestling stuff will come here in just a moment. I'm setting the stage for that. But man, with the UFC fighters and Leslie Smith, have you ever seen anything like that in your time doing this job, where you bring it all the way to the NLRB, the National Labor Relations Board, and because of somebody with influence, we believe, maybe a Dana White who didn't want this to happen and had friends that have got this thing thrown out. Have you ever seen anything like this in your career working so far?
No, that was a first for me. to initially be told at the regional level. So without getting too deep into the murky details, when you file a charge with the National Labor Relations Board or the NLRB, it's filed at the regional level. So the NLRB is divided across the country into these different regions. And so you file based on the region which is appropriate in terms of where the wrong occurred, or maybe where the employer is located, or something along these lines. And so in Leslie's case, we had filed in Region 4, which sits in Philadelphia. And what happens is then that region assigns an investigator, and the investigator investigates the charge. They speak with both parties, and then eventually they come up with a recommendation, and then that region decides whether they are going to issue what's called a merit determination, which essentially is saying, yes, your charge has merit. And then we, the NLRB, will file a complaint against the employer in the event you can't reach a settlement. And so we, when I say we, I was Leslie and myself, were advised in, I think, June or July of 2018 by an investigator that was handling that case, that they were prepared, they being Region 4, to issue a merit determination in Leslie's favor on two important issues. One, a merit determination that the UFC fighters were misclassified as independent contractors, and two, that Leslie had been retaliated against because of her union organizing activity. So you can imagine, Leslie was elated. We were very happy, and unfortunately, that happiness lasted for a total of about 8 hours, I believe. And that same day, got a call back from the investigator saying, DC, specifically the Division of Advice, which at the time was headed up by former General Counsel Peter Robb, who has since been fired since Biden took office. And they took the case. After Region 4 had said we're going to issue a merit determination, and absent settlement, we will issue a complaint against the UFC. And then it stagnated for a few months. I did have a 2-hour meeting in DC with Peter Robb and I think about 6 other NLRB attorneys, which interestingly enough, they would not let Leslie attend, by the way. And unfortunately, they dismissed, I say the Division of Advice, the dismissal actually came on Region 4 letterhead, but it read like it was written by the Division of Advice. And then unfortunately, our only appeal rights after that were right back to Peter Robb, who we believe, it's our opinion, that had penned, or someone in his office had penned, the dismissal letter initially. And then, as you can expect, our appeal was denied as well. Interestingly enough, Leslie and I did a panel discussion shortly around that time period at Rutgers School of Labor Relations. And the third member on that panel was Myrna Liebman, who was a former chair of the NLRB. And she had some interesting thoughts, including she had not seen such a situation where the region had made a merit determination and then it was taken away by Division of Advice. So yeah, that was a first for me.
That sounds wild. And so now with Peter Robb out of the way, I believe there's been a couple turnovers at the NLRB since Biden came in, the Biden administration came in, correct?
True. What happened was literally on the day Biden was inaugurated, they sent a letter, they being the Biden administration, sent a letter to Peter Robb saying, you have 24 hours to resign or you're going to be terminated. And he refused to resign. And so they terminated him. And then what happened was his deputy attorney general took control or filled Robb's position. And then that person received a similar piece of correspondence from the Biden administration, which was, you have 24 hours to resign. I'm not sure whether that person resigned or was fired, but essentially what they did was they named an acting general counsel because it is a Senate confirmation position. And so the acting attorney general used to be the regional director out of Chicago, which interestingly enough was heavily involved in the decision-making process, or the case, if you'll remember, when the Northwestern football players tried to unionize, which initially was had favorable results for those football players, which was eventually overturned by the entire NLRB, I believe. And that individual is now the acting attorney general at the NLRB. And we just saw today that the White House has nominated Jennifer Abruzzo to fill that position permanently. And she has worked in the NLRB previously And I think her most recent position was counsel at the Communication Workers of America, which is a pretty sizable union in the country.
And so with this new leadership coming in, is it possible for you and Leslie to go back and present the case again, or would you have to completely restart the process over, go get with the certificates of the slips, and then basically go back from the beginning?
Leslie and I are currently in discussion over that issue, so I can't really comment on our plans and our strategy related to that. But what I can leave you with is that Leslie and I are discussing her options.
Fair enough. All right. Well, let's move to the wrestling stuff here. So, Lucas, you've worked with all these different people to help them get unionized. You obviously understand when people are misclassified. What is your reaction? I mean, we've been breaking these exclusives over at Wrestling Inc. about Vince McMahon and WWE restricting the performers from monetizing on third-party platforms, claiming ownership of their identity and social media platforms based off of the contracts they signed. You've been watching this all play out. I don't know if you've talked to any wrestlers or anybody in the community, but what is your take on these restrictions that have been put in place on the performers over the last 4 to 6 months?
Sure, yeah, and I have been following it as the news comes out, and I followed along with the third party platforms and the streaming and things along that. And I saw a recent article related to some sort of discipline process where wrestlers may get suspended or fined, or but it looked like a progressive discipline in relation to also third party platforms. And what I can say is that the more control that, let's just call them an employer, the more control that an employer or an entity exercises over its independent contractors, the less likely it is that they are actually independent contractors. And what's important to remember is that labels don't control. Labels don't control the analysis, right? Under the NLRB's current case law and their rules, they employ a 10 or sometimes 11 factor test to determine whether somebody is actually an independent contractor or whether they are what they call a statutory employee. And it's interesting to me because the more control you say, you're not allowed to go out on these third-party platforms and earn additional money outside of what you're earning here, well, that sounds an awfully lot like an employee, because the true meaning of an independent contractor is that you can serve one individual and then you can go and make your money at another place as well. In fact, there's this concept in the factor test about entrepreneurship availability, and so that would factor in as well. And then I kind of smirked when I read this article recently about the fines and the suspensions, and because it just smacked to me of a progressive discipline policy, which is almost a benchmark of any union contract, which is not that you would put the progressive disciplinary steps in the contract, but most union contracts outside of the sports world have what's referred to as a just cause provision. And what that means is that you cannot be fired or disciplined without just cause. Now, that term is a loaded term. It's been analyzed over years of arbitration precedent and labor law. But one of the factors of just cause and whether or not the employee can be disciplined is a progressive discipline policy. Because progressive discipline is intended to rehabilitate an employee as opposed to strictly punish them. To say what you did was wrong, you need to correct your behavior, or else your next punishment could be worse, ultimately leading at the end of a progressive system, discharge. And so it's interesting because when we were prosecuting Leslie's case at the regional level, one of the pieces of evidence was the conduct policy that the UFC had implemented in 2018, and that policy had some hints of progressive discipline as well. And so that is an important factor when you're looking at whether somebody is an employee or an independent contractor. So again, the more that the WWE and Vince McMahon exercise this control over the work life, the more likely it is that a finding would be made if it ever reached that level, that the wrestlers are actually employees and not independent contractors. They're just currently misclassified and probably 1099 as an independent contractor as well.
So this is obviously, like you're a professional and you're looking at this thing and you're saying red flag, red flag, red flag. And I think even a casual observer at this point is looking at what's going on and saying the same thing, but nothing seems to be happening, Lucas. So like, what do you think should be going on here? Would you encourage the performers to act on their best behalf? Do you think there's an outside entity that can be working to better classify them? Like, what do you think should be going on in this moment, Lucas?
It really all depends on what the temperature is of the group that would be seeking to organize, right? Is the group unhappy with their current situation? Are they unhappy with the amount of control that the WWE exercises, despite the fact that they've signed contracts, I would assume, that say they're independent contractors?
Correct.
And any successful organizing drive usually kicks off with a level of unhappiness. And the ones that kind of seem to go very quickly, they have one linchpin item that all of a sudden has galvanized the group and makes them want to organize, right? But the process of organizing itself is relatively simple. You could collect cards, obviously, with what are called authorization cards, and they're just one-page small cards that have a little bit of identifying information, a date, a signature, and then once you get 30%, at least 30% of the roster to sign those cards, then you can submit the cards to the NLRB. And if the NLRB goes through the process and verifies that, in fact, they are authentic and the signatures match and everything, then you could proceed to an election to determine whether the entity that submitted the cards is going to be your collective bargaining representative. You can do that from the ground up, right? You can do that as a grassroots effort where the wrestlers could literally make something, let's say the wrestlers employment association, or right, something that make up their own name, put it on the union cards and create a union from the ground up. For instance, that's what the professional soccer referees did back in 2012, 2013, the Professional Soccer Referees Association.
And I don't want to belabor the point because I talked a little bit about this with Leslie, but just as a refresh for everybody that's listening and may not have caught it, this is a process because a lot of people fear retaliation, right? I mean, Leslie, like you say, her case was given credibility that seemed to be retaliatory because of her attempt to unionize. A lot of people worry about that, but it is possible to do this in a way where it is not anonymous, but discreet, so that your employer does not find out that you've actively participated in issuing your card in the unionization process, correct?
That's right. One of the important aspects of the National Labor Relations Act is that the union authorization cards are confidential. And in fact, the employer never sees who signed a card and who did not sign a card. They are submitted to the NLRB if it goes to that portion, and the NLRB will request essentially signature samples and a list of the potential bargaining unit from the employer, and they'll compare the two. But the employer never sees the cards or who signed and who did not sign the cards. And so what is important if you're doing a grassroots organizing effort is to ensure that confidentiality is protected in a manner where people don't have to fear that the employer is going to find out who did and who did not sign a card. And even if you go, and I know I'm kind of going deep into the intricacies here, but there's a concept called voluntary recognition, where if you collect enough of the cards, let's call it a majority of the group. So if you have just an overwhelming response to your organizing drive, then you can reach out to the company prior to filing with the NLRB. And you can say, we would like you to voluntarily recognize us. These cards demonstrate we have more than a majority support. Even in that situation, typically what happens is the parties agree to send the cards to a third party, like the American Arbitration Association. And then that third party verifies that the cards are accurate and potentially cross-reference them with signature samples. And if they verify they're accurate, and the company or the employer has agreed to this voluntary recognition process, then you don't even have to go to a union election. Once the cards are verified as accurate, if you have a majority, then you'll enter into what's called a voluntary recognition agreement. And then you can actually be the certified or the authorized bargaining representative through that route as well. And so even in that route, even in that path, the employer doesn't see who signed cards and who did not.
And the other thing to follow up on would be the pool. So you say 30% would need to get these cards to even begin a conversation about going to the NLRB. One question that comes up with a lot of fans is like, is that AEW and WWE? Can you do it just as WWE talent? Does it have to be talent that's just on TV? Can it be these 400 people they have sitting at the performance center as independent contractors who have yet to be brought up on TV? Where does that threshold go for what the pool looks like and where you would need to get 30% of those people?
Yeah, and I'll apologize in advance. Is that just I don't have a direct answer for you because some research and investigation would have to be done on what is the appropriate bargaining unit. And so that could be a look at if there are these subunits or if really they are all just one collective unit. And so there would need to be some research undertaken on the front end to determine what the appropriate unit is before you either sought voluntary recognition or even proceeded to the NLRB. And sometimes the NLRB even makes what's called unit determinations if that becomes a contested issue.
Okay. And one of the things I want to ask you about as well, have you heard, I mean, I know you talked to a lot of people, but I mean, do you get the impression there could be a unionization effort underway for pro wrestling already? I wonder that sometimes because it's kind of gotten quiet. I don't know what people are doing behind closed doors. Have you heard any rumblings about moves being made to potentially create a union for these performers right now?
No, not to no, I haven't heard anything, and I'm kind of on the outside looking in. As are you, and you actually may be more in tune with the community than am I, honestly.
I don't know. I know a lot of people ask you for advice, obviously, a lot of different ways. Well, and then lastly here, and again, this may be something you don't know anything about, but there's a lot of speculation that like WWE could be absolved or absorbed into NBC, like a complete buyout, and then they could become a part of that bigger NBC bubble. Do you think that would automatically change their status at all, or would it be possible for NBC to kind of keep them in this limbo, even though, they're a much bigger entity? I'm not really sure if that would affect anything.
I mean, if they're bought out by a bigger corporate parent, or if there's some sort of a merger, if let's just say if you unionize prior to that, then the unionization follows you.
Oh, okay. So if you unionize before some kind of merger happens, once NBC purchases, or if they purchase WWE, that union would become a part of the package and would have to travel.
Yeah, exactly right. Because if the law was otherwise, then the moment a company's employee is unionized, they could simply shut down that one, create a new corporate entity, and move everything over. And there are instances in case law addressing that. So no, the unionization, if you were certified or authorized prior to any type of corporate transaction or merger, it follows the merger.
All right, man. Well, that was actually way more of an answer than I was expecting for that question. That was very good. Thank you. You're like a real lawyer. That's great. All right, Lucas. I want to thank you so much for taking time out of your busy day, man. I think I owe you $27,000 for this 20 minutes that we had spent chatting here.
No, I'm not that expensive. I'm a union side lawyer, so that's the other guys that represent management that get to charge that much.
Okay, great, good to know. All right, Lucas, is there anything that you want to? I mean, do you want to promote anything? You want to send people to find information about a project you're passionate about, anything like that, before we wrap it up here today?
No, not necessarily. I just always just tell if people are truly interested in organizing, that there's always a fear that comes with that, right? So that's not unique to the UFC or the WWE or any group, right? It could be Bob's Vacuum Factory. There's gonna be that sense of fear. Just understand that the law does protect you against that retaliation. It is illegal. There is a process by which you would have to undergo, if it happened, obviously a legal process, but it is illegal. And that the key to any successful organizing drive is education. It's education. People really need to understand what it means to be unionized and what type of protections under the law and your collective bargaining agreement, once you get one, that could be beneficial to you. And what I found helping groups organize and talking to people is that there's a lot of misconceptions and misunderstandings about what it actually means and what type of leverage you would have as a group after you unionize. And so it's just important, if people are interested, to either try to educate yourself or to find someone like a Leslie Smith who would be willing to talk to you, who went through it herself, and who is actually in grad school now for, her bachelor's degree in labor relations at Rutgers. And she's a wealth of knowledge, a non-attorney wealth of knowledge, and someone who's very passionate about it as well. And so education is the key. And then the last thing I'll point out again is that there was a new law introduced into Congress called the PRO, or Protecting the Right to Organize, which, if passed, and that could be many months or years away, it would transform the NLRA in a very union-friendly manner, including changing the test for independent contractor to one more similar to California's, which is called the ABC test, which is way more employee friendly and militates in favor of a finding of employee status.